Pre or post trial traditions, no. Certainly don't try that many cases anymore. The most of my time is spent in litigation and depositions, a lot of mediations, things that don't, that get cases resolved short of trial. And what I do know, and I'm grateful for, is truly the caliber of people I work with as co-defendants is, beyond description. For the most part, the caliber of the people I work with on the other side of the case are fine, upstanding people as well, and for that I'm very grateful. The practice of law is somewhat different. It can be contentious, but there are many fine people doing a very fine job, and that is what, for me, keeps me doing it.
One trial that I had, remember, cast of characters included Judge E. Albert Morrison of the Pierce County bench. Plaintiffs were Dick Francisco and Donna Ackman, and the plaintiffs' attorneys were two widow members who will remain anonymous, as will later become apparent. In any event, my client was Subterranean Incorporated, and I tried the case with Janet Reese, who was at that time an associate in my office. The facts of the accident were not complicated. Subterranean was a water drilling company, and it had been up on Whidbey Island drilling for water. And at the top of the cliff, buried down, it lost its brakes. And it went down. I can't remember how much it weighed, but I remember it was about 4 tons. And it ran and wiped out a bunch of cars sitting down waiting for the Whidbey ferry, including Mr. Francisco's car. But Mr. Francisco was frustrated because he was retired and couldn't make a wage loss claim. He was quite a nice man. He had founded the Forgotten Children's Fund. He had taught boxing to youngsters at the WAC, and he had allowed disabled children to ride horses at his ranch in Whidbey Island. In fact, they were coming back from Whidbey Island at the time of the accident. He tried to get a little too cute with his damages. Judge Morrison, I've been told not to admit liability, and Judge Morrison went through the alphabet, I think, 2 times, and outlining the reasons why my client was negligent. So it was the damages case. Francisco maintained that he couldn't train his horsemen because of an elbow injury he suffered of the accident. He then testified that he went down to Longacre and asked people for the best trainer of horses, and he was directed to a woman named Gina Johnson. There were letters introduced by the plaintiff's attorney outlining the arrangements that were to be made, how much Gina paid per hour when she had to exercise the horses, etc. I introduced some additional letters that the plaintiff's attorneys couldn't get in. I don't recall why. But plaintiff's attorneys were perplexed, and I was simply digging a deeper hole. In one of the letters, Gina referred to Mr. Francisco as Bart, and I asked her about that. It was kind of sheepish. She said, "That's my cowboy name." And I said, "Mr. Francisco, did Gina call you anything else other than Bart?" And he said, "I don't know. What do you mean?" I said, "Did she ever call you Dad?" She got all flustered. I said, "You didn't want the jury to know about that, did you?" And as a result, the damages, the jury came back with damages less than I recommended as being reasonable. I think the moral of the story is don't mess with the jury.
The tradition I have is my kids always listen to my openings and my closing, and I can remember the last time, it was a month-long trial, I was out of town, so my kids came to closing. It was nice that they came to watch closing, and I just remember them afterwards saying, after they'd listened to the other side, I said, well, what was that guy talking about? That guy was really boring, but Dad, you really had them. They even put away their Sudokus that they were playing during his closing, and they actually listened to you. So I mean, it's always good to involve the kids in the you know, in your profession.
Jeff Tilden and I were arguing against each other in the Ninth Circuit, and as we're sitting there, the other cases are being argued. On the panel was a judge, for some reason, from the District of Kentucky, sitting by designation in the Ninth Circuit. And this guy had the Southern accent, you know, every stereotype you want to pick about a judge in Kentucky, he had it. And so right about before we were about to argue, Jeff slides over to me and said, I'll give you $100 if you work the phrase, "that dog won't hunt," into your argument. Unfortunately, I didn't work it in. I left the $100 on the table. I lost the case anyway, and so I might as well have used that phrase.
My best memory, I think, is the first case I tried by myself here in Seattle. I had prepared endlessly, perhaps a little too much for it, and knew that the plaintiffs wanted to get a particular piece of evidence in badly that I couldn't exclude in limine. And I had prepared every way from Sunday in a way to keep them from getting it in simply by objection. Just a few minutes before break, plaintiff's counsel asked the question one way. I objected. It was sustained. He thought for a minute. He asked it a second way, for which I had already also prepared, and I objected. It was sustained again. He asked a third way, and I had prepared for that way too. I objected on a different ground. It was sustained, and then the court recessed. It was great fun.
I had a case out of Oklahoma, Broken Bow, Oklahoma. We used to fly to Dallas and drive to Broken Bow and and do things there. But the two quick stories on that were that we were at a motion in Broken Bow, Idabel, Oklahoma, and the judge was getting very angry and dressing down one of the lawyers. And he looked over at the court reporter that was typing, and the court reporter put her hands down. And he laid into that lawyer and swore at him and said the most amazing things, obviously completely off the record. And then he looked back at the court reporter, and her hands came back up, and he started up typing again. That's the power of the bench in Broken Bow. But from that same case, we all went to Chicago to take depositions, a whole bunch of lawyers. I was the one taking the depositions, and so I couldn't participate in the fun. I had to drive the rest of the lawyers around through town. We stopped at a stoplight in downtown Chicago, and I had this Okie lawyer sitting next to me, and apparently a lady next to him was making a funny face at him, and he literally mooned her out the side of the window, put his bare butt against the window, and I had to peel off like we were in high school. And then he rolled down the window and sat on the window with his hands on the roof of the car, underneath the windowsill like this, and looked back and had me drive around the Sears Tower in downtown Chicago so that he could look up at the tallest building in the world over his head, and kept shouting out, "What a bull," around this building. And the cops finally shined a light on us, and he had to get in and take off. So that was a lot of fun.
Well, most of us here have all had defense verdicts, and we all like to talk about those, but I'm not going to talk about defense verdict. I'm going to talk about another case that I tried. It was a jury case in King County, personal injury. It took about 6 weeks to try. It involved a 2-year-old boy who unfortunately fell out of a second or third floor apartment window. He survived, but he had very serious injuries, including brain damage. And his family was represented by 3 very prominent plaintiff attorneys, and their demand going into trial was $10 million, not a penny less. My best liability witness was the apartment house manager, and right after the lawsuit was filed and I appeared, I had him come into my office. I spent about a half an hour with him going over just maintenance at the apartment complex and so forth. Didn't really get into this guy's past at all. Well, as the litigation went on and as the trial date approached, plaintiff attorneys wanted to take his deposition, and I couldn't find him. I couldn't find him anywhere. And this, I lost sleep worrying about where this guy was, spent a lot of money trying to find him. Finally, we found him in a jail down in prison down in California. And fortunately, to my good fortune, they released him a couple of days before my trial started. And of course, I immediately let the plaintiff attorney know this, that I found him and I intended to use him as a witness. Well, they moved to exclude him, or in the alternative, they moved to take his deposition. And Judge Mattson refused to exclude him and said he's just a fact witness. You can take his deposition at night during the trial. I'll let you have an hour to take his deposition. The witness, we flew him into SeaTac. I personally went out and picked him up after trial one day because I wanted to spend time with him to prep him for his deposition. And as it turned out, he had a long criminal history. And when his deposition was taken that night, the entire hour was spent on his criminal history, and they didn't have time to ask him a question about any of the fact questions about the maintenance policies. And when the 60 minutes were up, I immediately closed down the deposition. But I waited until they left my office, which was in the IBM building at the time, and took him across the street to the Fairmont Hotel, the old Olympic Hotel, very plush hotel. And it was like a $500 a night room I got this guy. I wanted to control him. I didn't want him leaving the hotel. And I actually took him up to the hotel room because I wanted to come back at 7 o'clock the next morning and prep him for his trial testimony, which was going to occur the next day. We walked into the room, and keep in mind this guy had been in the prison system most of the last 15 years. And he looked around this room, he just couldn't believe it. And he opened the bathroom door and turned on the light, and I'll never forget what he said. He said, and pardon my French, "Jesus Christ, there's even a telephone in the shitter." Well, I really had to work on this guy the next day because he had a very foul mouth, and every other sentence had swear words. But as it turned out, he did testify, and I got him out of town as fast as I got him in town. And the jury was out for 3 days. They couldn't agree on a verdict, and so it was a hung jury. And a week after the trial finished, the case settled for the amount I offered before trial, which was $300,000.
Going into a trial with admitted liability, $52,000 in medical specials, and I got a defense verdict. So kind of the hat trick in terms of getting a defense verdict, even though we admitted that we caused the accident. So that was a lot of fun. It was a fun trial, and I just couldn't believe I got that good of a result.
As it happened in the mid-'80s, a Puget Power line truck that weighs maybe 4 tons rear-ended at a stoplight a service truck driven by the plaintiff. So our truck's 4 tons, his truck's 1 ton. We're going 2 miles an hour. It's our fault, but it's not a big deal. We admit liability, and he goes to see the chiropractor 50 times in the 2 months before trial, and we go to trial, and they're trying to turn this into their retirement. His wife testifies. I remember the couple's name and their lawyer, but I'll leave. History should forget both those. They're 65. The years have not been good to either of them. She testifies that she and her husband made love every night. Oh, they'd had a slew of kids. 5 kids, 8 kids, I don't know. She and her husband made love every night of their marriage until the rear-end collision when they went cold turkey. So that's the testimony. If I'd been trying the case alone, I wouldn't have cross-examined her at all, and I don't think I couldn't have. But I was trying it with a young woman named Katie Sandstrom, who went on to teach law at Seton Hall, much to my regret. And Katie had a lot of moxie, and she also had a completely inoffensive way about her, and her entire cross-examination was the following. She got up and she went around the table. She's still a long way from the plaintiff wife, and she waits 1 or 2 seconds longer than she should until she said something, and at that point she is sure that every person in the courtroom is staring straight at her. And at that point, Kitty unloaded her entire cross-examination. Every night? And then she sat out, and the jury had a conniption fit. They gave them their past medicals and nothing else.
I was involved in a very serious quadriplegic case defending the city of Seattle, co-counseling with the city attorney's office. I was retained by underwriters at Lloyd's who had an excess policy. And the jury went out on Halloween. And I promptly went home to take my kids out trick-or-treating because they were quite small then. And told my wife that if there was anything that occurred, we got a call from the court, she should get out in the driveway and honk the horn. Well, that happened, and I came running back with the kids, jumped in the car and went down to court. Arrived at the courthouse, but no other attorneys had arrived, and it was quite late at night. It was about 11 o'clock at night. And the judge said, well, we're not going to wait any longer. We'll take the verdict. And the judge asked the jury, is this your verdict? And the jury said yes, and just handed it to the bailiff and said the bailiff will now read the verdict. And at that moment, there was a huge commotion, and some screams came out of the jury box. One of the jurors had slumped over and passed out. And I was the only, there were 12 women jurors and a woman judge, a woman bailiff, a woman court reporter, and I was the only attorney in the only male in the courtroom. I jumped the rail, took the witness chair out, and began giving CPR to the juror, and continued that for about 40 minutes until the aid crew arrived and took the juror out. Unfortunately, she had had a stroke. She made it to the hospital, but she didn't survive the night. And we proceeded to take the jury, and I won that case. But that memory was a very vivid one. So even though you are trained to be a lawyer, you might have occasion to do a few other things.
My probably best litigation memory is at the end of a 2-week jury trial. The jury came back in with a verdict for my clients. One of my clients was a hospital, and it was great that they had won, but the other client was an individual, a nurse who was also a manager, and she had totally taken to heart the claim, which was race discrimination. She was just a really good-hearted, fair-minded person and really took it personally. And I felt the relief in her. She was sitting right next to me when the verdict came in, and I was just so happy to have been able to help her out that way.
My first one, Frank Roberts took me up to Port Angeles, and we represented a defendant who was a farmer. Also happened to be the mayor of Port Angeles, the former mayor of Port Angeles. He knew every juror in the box personally. 3 of his black Angus cattle escaped in the middle of the night and got onto Highway 101. And the plaintiff drove into the middle of one, the rear end of another one, and the head of the third one. And he sued our client for blocking the roadway with his cattle. And when we got there, it was the case had been dismissed on a summary judgment, reversed, and we tried it. He essentially selected the jury for us, and we got a defense verdict. And it was fun. It was unique.
It's a case I tried with Ron Layton. The Honorable Judge Layton now, back when he was a mere mortal, Gordon Thomas, he and I had a case in front of Judge Burgess, recently departed. And the thing that was most memorable about this was that Ron and I had had cases prior to that time, and we got along famously. I think much better than we got along with each of our respective clients. By the end of the case, we were so anxious to be done with it that when the judge said, you have 15 minutes before the end of the day, do you want to do your closing arguments now or do you want to do them tomorrow? Ron and I looked at each other and almost simultaneously said, let's do it now. And we proceeded to do our closing arguments, and I'm sure we both wowed the judge, but at the end, Judge Burgess, I think, concluded that my clients were sleazy and Ron's were greedy, and he gave us an appropriate result.
I remember doing it's not a trial memory, but my advice to young lawyers all the time when people ask me about trying cases. One of the first CLEs I ever taught back in the mid-90s was a trial tactics and strategies kind of a thing. And I don't even remember the attorney that was presenting with me, but the attorney stood up and said, trying a case is nothing like television. And I stood up and said, if you don't try a case like it's on television, you're probably going to lose. People have developed an expectation that trial work is going to be hard-hitting, that it's going to be poignant, that it's going to be brief, and that's something that I think the best trial lawyers I've ever seen have simply fallen into, telling a good story very efficiently.